A lead-based paint hazard is any condition that causes exposure to lead from lead-contaminated dust, soil, or paint, which is deteriorated to the point of causing adverse human health effects. If the structure on a property was built prior to 1978, the property is the target of separate state and federal environmental protection disclosure programs designed to prevent the poisoning of children by the presence of lead-based paint. 1978 is one of those dates in real estate you need to commit to memory. It is highly relevant both in the context of your professional practice and is extremely likely to be referenced on the state licensing exam. So I'll say it again. 1978. 1978. 1978. To remember this date, think of something significant to you that occurred during that year. Say the release of Space Invaders arcade game, or a movie you like. Anything that triggers the memory of 1978. Prior to 1978, lead was frequently used to pigment paint as it was durable and washable. However, lead is a highly toxic metal that is capable of causing a range of health problems. Young children are particularly at risk as they are more likely to ingest it. A seller's agent uses a federally mandated lead-based paint disclosure when selling or leasing a residential unit built before 1978 to notify the buyer or tenant whether lead-based paint or lead-based paint hazards are known to the owner to be present on the property. The disclosure gives the buyer or tenant an opportunity to conduct a risk assessment or inspection of the property. The existence of lead-based paint is also disclosed on the TDS, and thus it is brought to the attention of a prospective buyer or tenant in two separate locations. The lead-based paint disclosure form includes the following: the lead warning statement as written in federal regulations, the seller's statement disclosing the presence of known lead-based paint hazards, or the seller's lack of any knowledge of existing lead-based paint, a list of records or reports available to the seller which indicates the presence or lack of lead-based paint, which have been handed to the seller's agent, the buyer's statement acknowledging receipt of the LBP disclosure, any other information available to the owner, and the lead hazard information pamphlet entitled "Protect Your Family from Lead in Your Home." The buyer's statement acknowledging the buyer has received a 10-day opportunity to inspect the property or has agreed to reduce or waive the inspection period. The seller's agent's statement noting the seller has been informed of the owner's disclosure requirements and the agent is aware of their duty to ensure the seller complies with the requirements. And the signature of the seller, buyer, and the seller's agent. The owner and the seller's broker each keep a copy of the disclosure statement for at least 3 years from the close of escrow on the sales transaction. Further, the disclosure form is to be written in the language of the purchase agreement. For example, if the purchase agreement is in Spanish, then the lead-based paint disclosure must also be in Spanish. Exempt from the federal lead-based paint disclosures are foreclosure sales of residential properties. Yet, a foreclosing lender still has a common law duty to disclose property defects known to them at the time of the foreclosure sale.